Good afternoon, everybody. This is Omar Serrato with the Tilted Lawyer podcast. I'm here with Rachel Juarez, the ever more famous Rachel Juarez, to opine. I mean, I don't know. That was a weird thing to say.
Yeah, I'll go with it. It's fine.
Yeah, the world famous Rachel Juarez making her second appearance on the Tilted Lawyer podcast to hopefully give a better critique and analysis of Judge Liman's decision to fundamentally gut the claims of Justin Baldoni against Blake Lively, or the Wayfarer Parties against the Lively Parties. It was shocking a couple of days ago. I've sat with it now for a couple of days. I attempted to share some additional thoughts yesterday with Lauren on stream, but kind of saw how that went. We couldn't really get through it. There's technical issues, and then Lauren got bored, and then midway through. So
it is kind of boring. I'm not going to lie, but
no, it is. I couldn't nerd out with her the way that I had intended, so I just figured I'd do it with you. So what was your? I've spoken plenty about it now over the course of 2 live streams. What is your thoughts about what happened?
I mean, I was shocked. I was shocked that there was no leave to amend granted. And I was shocked that it felt to me like the judge was going out of his way.
Yeah.
And I'm not suggesting there's any issue. I'm not suggesting there's a conflict of interest.
Right.
I'll leave that to other people. But it felt like he went out of his way to dismiss this complaint without leave to amend. And like he was grasping for things.
I think that maybe 40% of the comments I'm getting is, hey, did you know that Judge Liman has a brother? There's a conflict of interest. And so I don't know what to think about that.
No, I don't know anything about that.
Yeah.
And I can't even opine.
Yeah, I'm not sure why that would even, I just care not to comment on it unless there's something more tangible. But yeah, it's been floating out there. Up until this point, I've not looked at Judge Baldoni's decisions, or Judge Baldoni. Judge Liman's decisions with anything other than, oh, well, that makes a lot of sense. You know, I understand why he would do that. Like, for example, the motion to strike Brian Friedman's declaration from the records where he was implying like there was some kind of extortion without facts, and say, look, I'm just saying, I know a guy. If it's not a thing, I'll dismiss it myself. If it is a thing, I want you to know this is why I'm going after the thing. And then the judge is like, this isn't even, what do you want me to do about this? This is nothing. This is, but he struck it right away. Like it was, he had it, and then an hour later it was stricken.
Yeah.
And then I just get, well, I mean, if it's prejudicial, if it's that prejudicial, I can understand why.
Right. Yeah.
People were upset with that. But then, these more recent decisions, I go back to like the request for an extension on discovery that Judge Liman denied. It's like, well, you haven't demonstrated any facts about why you would be prejudiced, so I'm going to deny it. And by the way, and similarly, I'm not going to extend your deadline to request to amend the complaints. And then Freeman's like, all right, fine. And they went with this, like, oh, so this judge is a stickler. But, he seemed even-handed. And the one hearing that they've had, just examining the transcript, he asked fair questions of both sides. He attacked both sides equally. I thought he had some relevant questions of law. But this one is the head-scratcher for me. And it's not even that he granted the 12B6 motions. He just did it, I feel like, prematurely without an ability to amend.
Yes.
And he did it in the face of case law that was presented to him in opposition to the 12B6s that suggested that the Second Circuit has a policy where when you're trying to prove conspiracy claims, fraud claims, defamation claims, where you have to prove actual malice, there's a little bit of grace given at the pleading stage because you might not have all of the facts. And so I was kind of expecting him to rule on it later or just tell him to amend or whatever, but he just straight up cut him off in the midst of discovery. And that's what was most puzzling to me. What did you think about that?
I mean, I went back actually after the motion to dismiss and read the opposition because I thought, my gosh, did I really not? I mean, he wrote a great order. And I thought, did I really misunderstand the law? And it didn't really actually seem like that. It seemed like he really stretched. He cited unpublished opinions when there were published opinions on point and had been cited to him. That was the thing that stood out to me the most when I went back and read the opposition, was there were a few points where there was published authority on point and he cited unpublished opinions. We all know that there are issues in federal court that are not well addressed and you have to cite unpublished opinions, but not when there's extensive Second Circuit authority on the topic, you know?
Yeah.
And it just, the concept of actual malice and what he said about how it could never be proven, it really read to me more like something that you would find at the end of a bench trial. Like, look, you just didn't prove actual malice. It read to me like a statement of decision at the end of a case, where it's like, look, I can't just infer that he had actual malice. You did nothing to prove it. Well, that's kind of what you're supposed to be able to do, more or less, at the pleading stage. It just has to be plausible. That's the word, plausible.
Yeah, plausible.
I thought it was. I thought most of it was.
Well, I felt that when he was reciting the facts, like, so this is what I understand. So you think that Ryan Reynolds and Blake Lively and all these other people put together a smear campaign and came up with these false sexual harassment allegations because they were trying to gain the upper hand to gain some film credits and steal the movie out from under you. Is basically what he said. That's how he kind of summarizes it. Yeah, that's pretty much it. Plausible or not, obviously there's some holes in there, but they were in the process of discovery. But then he goes so far as to say that, look, you guys have given me a whole lot of facts. There's a whole 168-page Exhibit A. There's a 220-page amended complaint. You guys have pled an awful lot of facts. It seems futile that I'm going to give you an opportunity to amend even with new facts, and somehow you're going to cure what ails these complaints. I don't see it. I'm just going to dismiss with prejudice. Focus on those other two things. So what he did, it just seemed a bit harsh is all.
It also felt a little bit to me like a gotcha. There were several points in there where I felt like he said, well, and that you didn't plead actual malice. And if you went back to the complaint, it's right. They were missing a conclusory sentence saying that there was actual malice present. But we all know that that's the kind of thing you're supposed to be able to cure. Those kind of motions to dismiss happen all the time. You forgot to plead one element of your claim or, something like that. And you're supposed to be given leave to amend at least once.
At least once, yeah. Granted, they've already amended once, but, that was like voluntarily.
Right, exactly. That was before any of the deficiencies in the complaint were identified. That was just their own.
So what do you think about his him getting rid of the malice element by stating that Ryan Reynolds, for a very specific reason, that Ryan Reynolds and Leslie Sloan probably believe Blake Lively, and therefore, is it plausible? He kind of got in this discussion. Is it plausible that they didn't deny? I don't know. It seems plausible that he denied his wife. I don't have enough facts. Therefore, I don't see how you could cure this. It's perfectly reasonable to me that he could have just believed what Lively was saying. And then, but isn't that the reason for, I feel like that's just a tribal issue. Like, if he's literally arguing two sides of the coin, isn't that just something that should go to a jury?
Yes. And I think and I mentioned this to you, I was kind of like going in a circle in my head earlier today. If Ryan Reynolds wanted to defend, so Ryan Reynolds made the sexual predator comment, right?
Yes.
It's attributed to him. Okay. If he wanted to defend, if he had a reason to believe that, he should have had to waive spousal privilege or marital privilege. Right. In order to say, Blake told me that this happened. And then discovery should have opened up into their marital communications, right? So how do you give him the benefit of, well, we're going to assume that a privileged conversation took place between husband and wife that nobody has said took place. We're just going to assume that happened. And because of that, give him an affirmative defense or, give him, I guess it's not affirmative defense, give him, the ability to show that he reasonably relied on a statement, but then not subject him to discovery on all of the other communications where she could have said, ha, 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 isn't this great? This lie that we've made up, it just kind of seemed like, and that's why it felt to me more like this was a decision being made on the merits where he was saying, look, now that all the evidence is in, I don't know. I'm not sure I buy what you're saying. It's just as plausible that this could have happened, just as plausible. So you haven't convinced me.
Yeah, I think you made the comment. It felt
on the merits. Yeah.
It felt more like a motion for summary judgment ruling than a 12b6.
Yes.
Which I agreed. He's literally arguing the sides. And if you have two sides to argue, isn't that enough for 12b6?
So. Yes.
And so I'm still thoroughly confused, but it kind of goes into like pleading strategy. Okay, so do you think that Friedman harmed himself, not just because, maybe the complaint was inartfully pled? Is it that he just put out too many facts where the judge is like, you already given me all of this, and so I don't see how more is going to help. And you know what? Because he made like several comments in the ruling. He's like, you gave me like 400 pages of stuff, and you expect me
what
to
else
just
are
like
you going to come up with, right?
yeah, like, and I'm supposed to just like neatly attribute this to each individual party and know what you're talking about. That's your job. You're supposed to, under Rule 8, you're supposed to plead in a way that makes sense or whatever. And he just kind of taking all these shots at the writing of the pleadings. But at the same time, it seems like he did a pretty good job of summarizing their position. I don't know. In terms of an appeal,
Yeah.
in terms of an appeal, do you think that this is in danger? Do you think it's in danger of reversal?
Well, so I've been kind of going down a rabbit hole myself, wondering if the reason that he gave them leave to replete a couple of the claims was to kind of test this out for an appellate purpose, right? If he had just dismissed outright, there would have been an immediate appeal, right? It would have made much more sense for it to be certified for intermediate interlocutory appeal, I think.
Right.
But now he kind of puts them to the choice. Are they going to amend or are they going to appeal? And I think you have to decline to amend in order to appeal.
I'm not sure about that.
Back to law school, maybe. Back to my law school. But I'm pretty sure that in order to take the interlocutory appeal, you have to decline to amend the pleadings, because you can't go on two tracks, right? You can't be litigating some claims that could end up with preclusive effect while you're appealing the dismissal of other claims.
Yeah, well, I think that I thought that they would probably just stay the proceedings until the appeal was done, and I don't know how far that would knock everything back. Time frame wise,
it would knock it back a ton. But first, they have to, if they were going to do that, they'd have to basically decline to amend, right? So what I'm wondering is he giving them the ability to amend one or two claims, smaller claims that might survive an amendment?
Yeah.
And then they're put to the test, right? Do they take interlocutory appeal? And obviously they can still challenge the partial dismissal after the trial's over, but
right.
In this case, that does very little good. And I think it would be a lot harder to make a case for a certification of an interlocutory appeal if you've got two of your intertwined claims that have survived. I'm not sure they would stay. I'm not sure he would certify it for an intermediate appeal if two of the 6 claims have survived.
Yeah, I'm not sure. And even then, so let's just say they wait until the whole thing is over.
Yeah.
And they come up with all of these new facts and discovery, and they've done a whole new trial. And let's just say Blake Lively just let some things slip on cross-examination, that would have went to these causes of action. Now they have these new facts. I'm pretty sure that the record on appeal would be limited to the pleadings, but then they'd have to potentially find a way to introduce these new facts that you see. And they'd have to deal with that on the appeal. Strategically, how would you handle it?
I don't know. I don't know.
Because I went back and forth yesterday. I mean, because you could try to do it now, just like on just a pure they got the law they got the law wrong, right?
Yeah.
Or just wait until they get the final judgment, and when everything's been finished. And I don't know how they would handle this. Friedman doesn't. I don't think that he even knows what he wants to do. He's kind of. It feels like he's waffling back and forth with it himself.
I think he is, and I think. To go back, you asked a while ago, do I think that this was, inartful pleading? Do I think this was a mistake they made? It was definitely inartful pleading, inartful pleading. But I think that was very strategic. I think, and I said this from the very beginning, they clearly did not write a complaint for the purpose of being the best complaint, the most artfully pled complaint that could be presented in federal court. Obviously not. They wrote a document that they could put up on, the lawsuit.com website. That's what they did, right? They created a document that was designed for media consumption. Now, it was also a complaint in a lawsuit, so I'm not saying that they did anything wrong.
Yeah.
But it was very obvious to me, from having seen many federal complaints, that this was not designed to be a well-pled complaint. It was designed to be a media tool. And that's based on the entirety of the complaint, but also the appendix, the 180-page appendix, right? I mean, when was the last time you saw a complaint with text message excerpts in it? Right?
It's been, well, I mean, in family court that happens a lot, but but certainly not in civil cases. I haven't seen it, honestly.
Right. And there are some, of course, and sometimes there's a text message that forms the basis of a claim, right? And that's clearly appropriate. But when it's just kind of like evidence that makes somebody look bad, that doesn't even go in a complaint. So I think it was a strategic decision. I don't think they ever counted on facing dismissal without leave to amend. I think they figured, you know what, if this is not well done, we'll have a chance to fix it.
Yeah, I've said the same. Like, I think I even said something similar very early on. It's like, this complaint feels like it was written for TMZ.
Yes.
Like, we don't need all of this extra stuff. Like, there's way too much stuff going on in these complaints. Like, this is not an. I had the same opinion that you did.
Yeah, way too much stuff. I mean, that's really that's like the best summary of the complaint. There was way too much stuff.
There's way too much stuff. Yeah, and they're like these transcripts of text messages, and like, why is this even in here? And like, I don't know. And they were going on about, they just went on about so much stuff. I forget how many pages it was, but in the very early days, I remember Lauren Knighty, she was going on, she had an 8-hour live stream reading through page by page, word for word, Blake Lively's complaint. She's better at it now. She skips over more stuff. I think she feels more confident to do that.
When is she going to law school, by the way? I mean, it's time, right?
I don't know, but if she's going to do it, now's the time.
Lauren?
And you know what? She's got the chops for it. I'll tell you that young lady is, she's a bright girl.
Totally.
She really is. Whether or not she has the patience for it is another story.
I mean, whether or not she's a boring enough human to be a lawyer, I don't have super confidence in that.
Yeah. I had her at my house yesterday, and she was drawing pictures with the girls and like playing her crazy music and dancing and all kinds of stuff, and using profanities in front of the children. I got accused of being a questionable parent by one of the they were joking. But Lauren, she got me in a little bit. She didn't get me in any trouble. She was fine. She did everything. She was wonderful. Anyway, there was this other issue. Okay.
Where did we stop? Strategy, right? What would be my strategy, you said?
I asked you about your strategy, but I wanted you to comment more on this. And you mentioned something about, well, you did mention a little bit about, marital privilege and all of that. But what do you think of Judge Liman's reasoning? Just straight up, if he understands conceptually that the Wayfarer parties are pleading that Ryan Reynolds and Blake Lively are co-conspirators.
Right.
And then the basis for knocking out a very crucial element of defamation is that, well, he believed his co-conspirator.
Right.
What the hell?
Right. And what does he expect? I understand the general concept that you can't just plead. I think that they conspired together. I understand you need a little bit more than that.
Yeah.
But it's very obvious. I mean, at one point he talks about how, well, it's not enough to have a motive and a hatred of someone. It's like, well, I don't know, it might be, right? Like when you're talking about malice, he says, well, it's not enough just to show that, you might have a motive to do it and then you might dislike someone. Like, no, I'm pretty sure that's enough to plead malice, right?
Yeah.
And he understood clearly because of the recitation of events that they were arguing that Ryan Reynolds hated Baldoni. And for him to go out on a limb and say, well, maybe he hated him because he sexually assaulted his wife.
Right.
Is kind of like, well, sure, maybe he hated him because they took a trip to Mars together and he got to meet the alien first. Like, there could be a lot of maybes. You do not have to plead around all the maybes. You have to have a plausible claim on its face. And certainly one plausible claim, which Judge Liman clearly understood, was that they had it out for this guy and they didn't like him and she wanted to take over the movie. How is that not sufficient to plead malice?
Yeah, so he ties it into extortion, right? Like he says, well, first of all, New York doesn't recognize civil extortion for one. That's a California thing.
Right.
And when they do recognize it, it's under the criminal context.
Yep.
And very clearly in every California case, whenever criminal extortion is a thing, there's some kind of monetary benefit gained. Yep. But what I've been going with from the very beginning, because I read those arguments like way back in January, from the very beginning, isn't it not a tangible benefit, the fact that you have the rights to this movie? Doesn't it have inherent intrinsic value? The movie literally made, I don't know how much money, like over $100 million or something. Don't quote me on that, but it made a lot of money. And Blake Lively was talking about this specific franchise going back to 2022, 2023, I think, in interviews, that she wanted to turn this into a franchise and have this be like $1 billion business. In other words, there was a lot at stake. But if you rely on the logic of the California Penal Code with civil extortion or criminal extortion, the way that Judge Liman was interpreting it, it left no room to be able to plead that this was their plan. They were extorting me over the rights to the movie. They were extorting me over movie credits that were intangibly valuable, that had an inherent value. And my understanding is
the best argument, I think.
Those are usually proven damages from experts at the time of trial,
yes,
at the appropriate time.
Absolutely. Right? You bring an expert in to say, how much does having the sole director credit? How much does having, the sole executive producer credit, right? How much does that translate to the next time you go to make a deal? They would have experts that would have opinions on that. One which would say 0 and one which would say $100 billion, I mean, but in reality, they'd have expert testimony on that. You don't know that at the pleading stage. You're pleading something that is clearly of value. But I will say, I was less surprised about the civil extortion. That one to me wasn't.
That's a rough claim. That is a rough cause of action for sure. Yeah.
If he had said the civil extortion claim is dismissed and some of the defamation claims are dismissed, the ones that related just to the pleading of the CRD complaint, I would have said a totally fair ruling, even if it was without leave to amend. I think that would have been much more understandable and digestible, because civil extortion is so difficult. It's that so much more was done that it's really difficult. And the other thing that was really tough for me on the defamation claims was the fact that the CRD complaint hadn't been filed yet. And we know that there's an exception for documents that are about to be filed. But there's a requirement, an absolute requirement, that the documents have to be filed in good faith. Yes. In the good faith pursuit of a lawsuit. How did he not understand from the pleadings that the argument was that the CRD complaint was a sham? And I know what he says is that, oh, well, no, it was an absolute precursor to a lawsuit, in court, which may or may not be true, depending on, how you read it. But even if it is true, we still claim it was a sham. So that's something that discovery should be done on. Let's see if there are communications saying, oh, we want to release this really bad, this really bad article. I guess we should do a CRD complaint in order to give us shield for it.
Sure.
Right? I mean, clearly there was a plausible allegation because of the timing, because of all of this, that was a sham lawsuit. Obviously.
I agree with that 100%. But I'll tell you this, though. What do you think about the New York Times being let off the hook?
I mean, it's so hard to sue these major publications. Yeah. And this gets into, to me, I understand the policy arguments surrounding, it does seem pretty crappy that you can just kind of give yourself a privilege by making a legal claim, right? By just making it worse, you're giving, for the other person, you're creating a privilege that wouldn't otherwise exist. Right. But it would also be a really bad policy for the media and for the public to have liability for an entity like that publishes a legal complaint. And that's the kind of thing where I really feel, and I know a lot of people disagree with me on this one, but anything other than a pretty bright line is very difficult. And it would really chill, I think, public discourse.
No, I agree with that.
Yeah, if you started saying, oh, well, the New York Times should have known that it was a sham lawsuit, right?
How? But how would it possibly?
Know? So I'm okay with them being let off. I mean, I think there were shenanigans going on behind the scenes.
There might have been.
Yeah, I think they were aware that this was, before the lawsuit was being filed. And, if they really read all the text messages like they claimed they did, they know they were being selectively published.
I'll tell you what, though.
I don't really know how you go against the. I think that's a tough one.
Well, my the way that I kind of think of it the same way as you.
Yeah.
What do you want them to do? Maybe they did exchange like thousands of text messages months before, but all they reported was what was in the CRD complaint. Right. They give Justin like 30 minutes to respond, and then he doesn't respond, and they run with the story. What did they do illegal?
Yeah.
I get that point of it, but and at the same time, to your point, like how would they know it was a sham lawsuit? In my very limited experience of dealing with media and publications like the Daily Mail, they call you and they ask you questions, and you give them some legal analysis and think, oh, that's very interesting. They're just looking for a soundbite.
Yeah,
they're just looking for like real, like quick stuff. Like they're not going. I don't think that they're Google checking what I'm saying. You know, they're just, what do you think about this? What do you think about that? And they're literally just recording what they interpreted me to say, or unless it's like a direct quote. But they're not lawyers,
right?
And so even we didn't know anything about the Van Sham thing until months after the fact. And that's an entirely different, I called it evidence laundering. Let's just make a sham lawsuit.
That's great. I love that. It is evidence laundering. That's
what it was.
I mean, that's exactly what it is. It's cleaning it through the laundering process, which, by the way, is legal. You're allowed to do that. I mean, now, are there issues of good faith and ethics? Yes, but has anything illegal been done? No.
Not technically. Not. I mean, but shitty. Definitely something shitty's been done.
Something shitty and unethical and improper. Yeah, absolutely. I just don't know that to me, this is kind of like, you know, when somebody who's not the police and who isn't acting at the behest of the police breaks in and gets the evidence illegally, you know, that's really shitty, but it actually, you don't have standing to challenge it, you know, or when somebody breaks into someone else's home or the police go in and they find your stuff there and you had no expectation of privacy. You don't have standing to challenge the search, even though what happened is super shitty.
You know, what's funny?
It's kind of like what's going on here.
Judge Elizabeth Scherer, I don't know if you know who she is. She was the judge that oversaw the sentencing hearing for the Parkland case a couple of years back.
Oh, yeah, of course.
But she had an opinion. She's like, look, I look at it, the Van Sham lawsuit. She said, I look at it as if it's like fruit of the poisonous tree. I feel like you obtained this evidence unethically. And what she stated, she's a former judge. She said, if that were in my courtroom, I would completely disregard it. I would toss it. And I don't know if she's right or wrong in that, but I understand the sentiment, fruit of the poisonous tree.
I don't think there's anything wrong with the judge saying I would toss it, because I think it was obtained unethically and not in good faith.
Yeah.
I just don't know that you have to toss it, right? Because I think the person that has the claim here is not Justin Baldoni.
I think that people have been waiting for Brian Friedman to do something about it, like file a motion. Like, what motion? What did she do wrong? You know, like a motion about the illegal subpoena, you know, to the extent that it's affecting this case.
It's a motion in limine, right? Which,
probably.
We call a motion in lemonade because
lemonade.
Steve thought it was a motion in lemonade. But yeah, it's a motion in limine to me at the time of trial. They say we don't want any evidence that came from this sham subpoena at trial because it was obtained unethically. I don't know if there's anything to do about it right now.
Well, I think that if you were to write or if you were to conjure up a motion, you know, maybe you would say that, look, the basis of this litigation comes from this evidence laundering Van Sham lawsuit where they faked a lawsuit without any named defendants. The defendants were Does 1 through 10.
Yeah.
And they obtained subpoena power, had nobody to notice. Right. And so they sent the subpoena, they get this information, and whatever they got from it led to this lawsuit. Therefore, I want the entire thing tossed. I want her entire complaint tossed, and I want to be able to prevail on my counterclaim. I know it's not going to work, but I feel like that's what people want to see happen.
Yeah.
You know?
Where was that case filed?
That was in New York.
Yeah. Well, because if it were filed in California, they'd have to give consumer notice, right?
Right. So that's not a requirement in New York.
California. So I know I talked about this a while ago, but when we were first talking about the concept of, you know, was it a sham subpoena? Was there a sham lawsuit? You know, before we knew where it might be or anything, I said, well, in California, you couldn't do that because you'd have to give consumer notice to every client of that firm. You'd have to give it to all these people whose records are going to be produced. I love it. Thanks, Lauren. Hi.
I'm sorry, which one of us got your kid in trouble for calling people shitbags at school?
Oh my God.
My children may or may not have called others shitbags at school.
They probably were being shitbags, you know.
They probably were.
Get a ruling on that. So anyway, in California, what they did would not have been possible because you would have had to give notice to everybody who was affected by the subpoena. So yeah, it's super shitty what happened. I just don't, to me, that's an issue that's like a civil damages issue between the employee whose phone they took and, you know, Jones Works and the employee, and probably she doesn't even have a remedy.
I'll tell you what, I would probably be the brazen attorney to go and file some crazy motion like that. I want the entire complaint dismissed. I'm putting the whole system on trial. Yeah. This was a farce. You know, I know I wouldn't win a motion like that, but I'd at least want it out there, you know, and maybe that would serve to have some PR benefit because people are already looking at it that way.
It could. The problem is, I really think that what happened here was Liman was pissed at Friedman. And I think there were so many references throughout the order to, you know, the inartfully pled complaint, which had all of these, you know, that had all of these. I mean, he was overly critical, in my opinion, of the complaint, which wasn't a fabulous complaint, and so many times you jam-packed so much irrelevant stuff in there. I think he was trying to say, I know what you're trying to do. I know you're trying to use my courtroom as a pulpit, and I know you're using it. I mean, he smashed him a few times for writing that letter that was not appropriate.
Mm-hmm.
And I think that it was a real shot at him for using this as a PR tool. And so I think a motion like that in this circumstance would just further piss off Liman.
Probably.
Right? Conjuring up some motion.
Yeah.
But maybe you make it like a motion for a protective order, so that none of that material can be used in discovery, pending further hearing. I don't know, you know, that nobody can be deposed about that stuff.
I mean, I like that better than the motion in limine idea, you know, where we got to wait all the way till trial to figure out whether or not.
Yeah.
I like that idea. I'll tell you what, as far as inartfully pled complaints, I've seen a lot worse.
Oh, of course. Of course.
It wasn't that bad. I mean, it was fun to read, but we know what he was doing. Everybody knows what he was doing. I just don't know why Judge Liman is so pissed about it, given that the lively parties kind of did the same thing, just not as effectively as Friedman.
Right.
Is my opinion.
And they amended to do it more without even changing their claims. I mean, their first amendment was just to make it more Friedman-esque. It didn't even really change anything that they had in there. They just put more crap in. So
exactly.
You know, I get it, but he's clearly pissed at Friedman. I think there's probably an issue of, you know, Lively's firm is in federal court all the time. I don't know that Brian Friedman is. You know, a repeat player issue. You know, he's got this kind of upstart state court lawyer, you know, coming and dominating the press. I think he's.
So let me ask you then. I'm going to ask you just a question based on your own experience.
Sure.
You know, attorney-judge relationships, it's a love-hate relationship, man. You respect the judges.
Yeah.
And when you get these bad decisions, you respect them because you work with these people. You see them, you know, day in, day out, whatever. But there are definitely times where, as an attorney, I know for a fact that the judge has the law wrong.
Yeah.
And they're looking at it wrong. And there are times where it is so egregious where I'm having to contain myself in court from going too far because I want to be respectful of the judge. Have you ever been in a situation where you were just so much in disagreement as an attorney arguing in front of a judge where you just knew that you knew the law better than this judge and you had to like deal with it somehow?
I had a trial where we were in front of a private judge and the rulings were so outrageous that we thought something is not right. And it turned out there was an undisclosed financial relationship between her and the other party. Not the other party, but the other counsel. And we had the entire case all the way back to the beginning tossed out by an independent judge in Orange County, reviewing it and finding that the judge should not have been presiding over the case without disclosing this relationship.
Yeah.
You know, and that's a tough motion to have to make, right? Is like, I mean, a motion for disqualification, right?
Yeah.
And basically going all the way back and saying you're biased because it feels like sour apples, you know, like Oh, I lost, and we got a big loss. We got a lot of losses in that case, but ones that we didn't really understand, right? I don't always win. I mean, I'd love to say I do, but I don't always win. But I usually understand. I get it.
Yeah.
That one was just like baffling. We didn't get it, and it was just by happenstance when we were doing the post judgment stuff, not post judgment, but like post trial stuff, that we asked her to disclose if there had been any conflicts of interest that we should be aware of. And she was like, oh yeah, here's 15 of them I forgot to tell you about.
Jesus.
And we were like, what? And so we filed a motion to disqualify, which has to go to a different superior court system, right? Because it can't be there, the LA Superior Court.
Yeah.
So it went to Orange County, and he said, absolutely, this was totally improper. Case is out. Everything the judges decided back to the second month of the case is out. And we're doing it all again. So we did the entire case again.
Oh, that would have frustrated me so much.
Yeah. And it's horrible for everybody, but especially for the client who's got to pay for it to be done twice.
Yeah. Yeah. No, for sure.
Yeah.
And it's like, well, how much does this case mean to you?
Yeah.
Because we got to do it again. And so I don't know what to tell you. Thank you, Redondo Beach, for being a member for 7 months. She says, oh man, I'm trying to stay awake for this. I'm going to be half live, half replay.
Thanks for staying awake.
Yeah, I do not fault you for that, Redondo. And your time on the bench, what's like the
hot bench?
On the hot bench. Yeah. What's the craziest interaction you've had with somebody that was just really pissed at you?
I don't know.
I know that's like a loaded question.
Yeah. I mean, probably the guy that like threw his papers at us. I mean, they didn't go very far because he was really far away. But he threw his papers at us and walked away. And he was a lawyer, or so he said.
Oh.
And we were all like, come on. And then we found out he'd been on Big Brother. I mean, just
he was on Big Brother. Yeah. Was he actually a lawyer though?
It appeared so. He appeared. It appeared like the credentials that he gave matched up to a law license in California. We can't really ever be sure. I think that's the worst one, with somebody being really angry. A lot of people who are just not respectful.
Yeah.
As opposed to angry. A lot of people who are like, honey, you don't understand. Sweetheart, you don't. No.
Oh, shit.
Your Honor is good.
You will be respectful and call me Your Honor.
Yeah.
Address me by the proper respect.
But not a lot of like, not a lot of real anger.
Yeah.
I
wanted to ask you really quick about 47.1. Here's my biggest concern for Baldoni. Is that nobody really seems to know how 47.1 is going to play out. I mean, I'm statute, no case law.
You're not going to tell me like to give you the answer because I don't know.
I'm not. Nobody knows. I don't know. Nobody knows. I don't expect you to know.
Yeah.
But my biggest fear for him is that this is going to invoke treble damages.
Yeah.
For no reason.
No reason.
Yeah. And how could you claim that he hasn't been prejudiced when he's facing 47.1 treble damages for what has now been dismissed with prejudice for having no hope on even an amended complaint? That's what I was worried about the most with respect to the defamation claim, which I wouldn't even really think about. Look, I mean, normally, fine, we're not doing defamation. I get it. We're not doing extortion. Focus on the other two, focus on defending ourselves. I'm not changing my strategy whatsoever on the discovery. If you want to object to me, object, and then we could ferret that out. And discovery motions or whatnot, we still got until February of next year, to figure that out. What's that, another 8 months?
They're not going in March. I mean, come on.
I don't know, Judge Liman.
They are, but I mean, there's just so much more. I just, with all the litigation going, I just don't foresee there not being something else that holds this up, at least a little.
I agree with you, but then I see decisions like Judge Liman refusing to extend a deadline on discovery,
I know.
For stupid reasons, which I thought, but I didn't say that at the time because it's being respectful. I said, all right, he wants to be a stickler. Those are the rules. We're not granting extensions. Fair. At least we know how he's going to rule.
It's not really fair. I mean, I don't remember the last time a judge in massive litigation was like no discovery extensions.
Yeah, no. I mean, I'll tell you what, Judge Liman has been making a liar out of me in this case multiple times, because I
Oh,
was telling people, oh, they're going to grant it. What's the big deal? You want an extra 30 days? Who cares? Give them 30 days. We got until February of next year. What was the big deal? But he was really harsh with his ruling,
yeah.
particularly to Friedman, the Wayfarer Parties. And people's like, oh, he's obviously biased. Oh, no, never mind about that. The motion to strike, hey, he granted that within like an hour of it being brought on his desk. He's like, oh, but, I understand the reasoning, whatever, fine. He's trying to control things. But now this 12B6 dismissal. Okay, now hold on a minute. No.
Yeah.
Why don't we slow down? What's really going on? I'm not going to say that he's biased. I'm not going to say that.
I wouldn't either.
I just am puzzled, knowing what I know about the law, at some of these decisions, knowing what's been cited in front of him in some of these 12v6 motions, not giving, and we've already, I'm not going to rehash the whole thing, but I'm just puzzled at how harsh he's been towards the Wayfarer Parties.
Yeah.
I can see why people think it's one-sided.
I can too. And I think it has been one-sided, but that, to me, that's different than biased in a way, right? Like it has been one-sided, but not necessarily improperly. There's just no basis for us to conclude that he's improperly biased at this point.
No.
But it has been very one-sided. I don't think that's just something that we're imagining.
Yeah, no, for sure.
So,
I mean, the result of the case is that for whatever reason, Baldoni only has 2 causes of action left.
Yeah.
And it feels bad. I feel like most of the people that are following this case are of the opinion that Baldoni has a stronger case.
Yeah.
And so it feels like, people are like mourning this decision like it's a funeral, like they've lost something. This isn't over. But I can definitely see. Yeah.
But it's going to be devastating if they go to trial without counterclaims, because in addition to like having merit, the counterclaims are going to balance out the claims, and if they go without any counterclaims, oh my God, they're going to be in big trouble.
How often in your litigation career had you ever proceeded with the defendant without filing a countersuit? I've just always wondered, like, if you're the defendant, if you're on the defendant's side, and there's like this this event that went itself to litigation, why would the defendant not countersue?
Yeah, obviously in family law, it's not really a thing, but in civil litigation, which I practiced for a lot of years first, I can't think of any big cases I was involved in where there wasn't a countersuit.
Right. It's just such a strategic error, I feel like. Yeah. Because they're able to just litigate without pressure, and like you're under the gun the entire time, and all you could recover is attorney fees and costs, maybe. But attorney fees and costs are so hard. Yeah. And so, and whenever you have a transaction that's that large, or an event that's that large that leads to that many damages, the other side's going to have some type of argument that they were damaged instead. It's never just really going to be the case. Unless you're talking about law that I never practiced, like a slip and fall or something, Yes, if you slip in a Walmart and break your leg, it's hard for Walmart to have a claim against you. But for sure, anything, a car accident, or the huge transactions that we've done, the huge, company on company transactions and stuff. Somebody's damaged. The other person's going to claim they were damaged. It's not that difficult. So the last thing I wanted to ask you about was, what was your opinion? I got to read Redondo Beach's comment. My dad was a judge. I had to cover his face once because something was so funny he could barely keep it together.
Oh, yeah. By the way, that happens on Hot Bench all the time. But instead of having our kids there to cover our faces, we have editors.
Oh, Lauren says, this is for your Spotify bill, you Disney princess-loving psycho. I had Lauren in my car, and she wanted to play Hannah Montana. And then she was shooting videos of me listening to Hannah Montana, and the look on my face, and she put it on her Instagram story. It's like, Lauren, and she's just nerding out to Hannah Montana. Anyway, I want to ask you about Judge Liman refers to the Wayfarer's allegations of extortion efforts, conspiracy, and all of that as hard bargaining. So here's what I thought. Very early on when I was reading these complaints, it's like, this is going to be a problem them continuously acquiescing to Blake Lively's demands over and over again, and telling her in text messages what a genius she is and how artistic she is and like what a valuable asset she is. And we'll do whatever you need, and continuously giving into her. They didn't frame the four corners of a contract, and they're going to amend the complaint to figure that out. There was never a signed physical contract between the parties. Obviously, they're going to have to find it through their conduct.
Yeah.
But Judge Liman goes further to state that the Wayfarer parties had other remedies than continuing on with Blake Lively. And I'm like, how? Yeah. When the movie was in post-production, they already made the entire movie. What was the remedy that they were going to do, you know?
I thought that was the worst sentence of the entire order, was when he said they had another remedy, a lawsuit.
Yeah, you said that to me in direct message.
Yeah,
you said
no. Now look, we face this issue all the time in civil litigation, right? If you acquiesce, you lose a basis for a cause of action, right?
Right.
You have to do one or the other, and we see this all the time on hot bench too. Is people agree to resolve something, right? They say, okay, just give me $1,000 back, and then they sue. And we say, you don't get to do that. That's an accord and satisfaction. Like if you say, just give me $1,000 back, and they do it, you don't have a lawsuit anymore. That's not to say you did something wrong, because frankly, that's better than a $2,000 lawsuit. It's just getting $1,000 back. But I don't know how anybody could argue that just filing a lawsuit there would have been an adequate remedy. And I think it would have been a lawsuit that wasn't ripe.
Yeah. Judge Liman's reasoning, it just feels like, look, if he wanted to rule the other way, he totally could have. Because he could have totally made an argument like, yeah, what would the Wayfarer Parties do? They already made a movie, completely made it. There was months and months of production and cost and expense. They have the movie made, and now she's making all these demands, and she wants editor rights. That was never contemplated early on. And they can't just renege on it now and refilm the entire thing. That would cost hundreds of millions of dollars. I mean, I don't know how much, but millions of dollars for sure. And, all the other things that they were talking about, for him to say that they had other remedies and to just offer that, it felt like he was arguing against the Wayfarer Parties.
Absolutely.
Impermissibly.
Yeah, absolutely. The other thing that I think he really failed to account for was the union rules. Right? A lot of what she was asking for was contrary to union rules, right? That guarantee, right? Like the DGA and the Writers Guild, but the DGA guarantees a director a certain amount of time with the cut before anybody else accesses it, things like that. If she is hard bargaining for them to violate union rules, that's not hard bargaining. That's a problem, is all I can kind of say, right? If I went to Hot Bench and said like, well, no, I will only film tomorrow if you don't let the camera guys go when they're legally entitled to go. That's a lot different than saying like, well, I don't want to do another season unless I get the snacks I like. That might be hard bargaining, right? But she's insisting on, and this is where I guess I was kind of ho-hum about the implied covenant claim at first, but it actually could have some meat on it, I think. Because, this whole issue of failing to promote the movie, we don't know what the four corners of the contract said. At least I don't know.
Right.
But certainly that has to be an implied covenant of good faith and fair dealing.
Sure.
That if you sign on as a major celebrity, you have to do reasonable promotional activity. That has to be an implied term.
Right.
Or you need to negotiate appropriately, right? You have to give me another $1 million if you want me to promote your film. It doesn't feel like saying I will only promote the film if you violate union rules, if you deprive union members like Justin Baldoni of the protections accorded him by his union on a union production. I assume it was a union production.
It was. I'm pretty sure it was.
Yeah, that's the only circumstances under which I will, engage in this good faith act of promoting the movie. That the existence of union rules and her insistence that they violate them seems like another kind of fly in the ointment there to me. Like, things that he's reaching for these plausible arguments when there are other plausible arguments. And that's
what I mean. Yeah.
At the motion to dismiss stage. You're supposed to be looking at, is there a plausible claim for relief?
Right.
And that's why I'm like, my broader take on this was it read to me like, yeah, maybe summary judgment or maybe just a statement of decision. Like, did you meet the preponderance of the evidence standard? Oof, I don't think you quite did because there were all these other possibilities out there. And I'm not convinced that yours was the 50.001% one, which is a completely different legal inquiry than have you stated a plausible claim for relief.
I mean, and just so people are aware, like if you're going to a jury trial, the judge doesn't get to make these decisions. He doesn't get to make these evidentiary calls. All you want to do is get it in front of them and make the points and let them decide whether or not they thought it was impermissible extortion. If you survive 12b6 and you get these to trial, then the jury is the trier of facts. And it doesn't matter what the judge's opinion is. They're just the umpire at that point, calling balls and strikes and objections and motions and limine and all of those things. But
it does matter what their opinion is.
Yeah,
it doesn't directly matter, right? Because it does matter, right? If they're because the umpire calling balls and strikes can call a lot of. They could be Angel Hernandez.
They could be a bad umpire for sure, and yeah, they absolutely could affect things.
But their opinion doesn't matter. It doesn't influence the directly. Yeah.
Where I have a problem with this judge is that he's counter arguing.
Yeah.
In a 12b6, and it feels shitty. It just feels wrong. It just feels, I understand why. It feels like he's going to bat for the lively parties in a way that he's not done ever for the Wayfarer parties.
And that's why I very much, I really think all those sort of like every judge in the world is biased, those things are out there. I completely understand people that believe he's biased, especially people that are not lawyers and in the legal system, because it reads like he is making their arguments for them. Some of these arguments he came up with on his own.
He did.
He didn't even argue them.
He did.
He said, well, Lively made a great point in her motion to dismiss, which is that he just came up with these arguments himself. and they really were. I mean, which is just so counterintuitive on a 12b6 to say like, well, there's several other explanations for that.
For sure.
That's just not what we have ever known a motion to dismiss to be about.
No, and I think that most lawyers that are looking in this case, most legal professionals looking at this case, intuitively, this doesn't make this. Intuitively, it feels wrong. It just feels wrong.
Yeah.
And it's creating these conundrums. I got to get to some of these. CJ says, no more huffing. Always fun to watch your legal takes and love your guest. Great insights. Oh, Rachel's the best.
Oh, thanks, guys.
Rachel's like one of the few people I've ever had on my show that I was intellectually intimidated by.
Oh no, you don't. Oh please.
I told Lauren that yesterday. That I just wanted to make sure I didn't sound stupid in front of Rachel.
No. I mean, I love nerding out on this stuff because there aren't a lot of people.
Sarah Dunn wants to know who's my daddy. Oh, that's a good question. I should ask my mom. No, I know who my daddy is.
So do I. Not interesting.
Yeah. Kelly Steffi says, just stopping in to send some love. Thanks, Kelly. Kelly with Amy in Boston. They're doing a lot of work on the Karen Reed trial. They're over there in Boston in person.
Done now?
They're still going.
Basically, but I mean, like they're basically at the end, aren't they?
Pretty much.
For defense, I think.
Yeah, pretty much. I don't feel like it's going very well for the prosecution.
No, I don't either.
I think that the DA, the guy that's trying the case, is screwing up pretty badly with some of these expert witnesses. Yeah. That's another topic for another show.
Totally other show. But the fact that they didn't even call like Trooper Proctor or anyone, to me, tells me that they're in there reading the room. And Alan Jackson knows how to read a courtroom,
Yeah.
They don't even need to do that. They don't even need to put really all that conspiracy and all the bad police conduct. They don't really need to harp on that. They've just the actual evidence is enough. Which
is it just me, or does it feel like this trial number 2 is going worse than trial number 1 for the prosecution?
Oh, 1,000%.
I just want to make sure that I'm not missing something.
100%. 100%. Coming out of the first trial, I think, and I think I said this last time, my take on it was like, she probably more likely than not did it, but I would never find her guilty in a court of law. Like I'd never convict her criminally for it. And now with these experts, I don't even think I would say probably did it. I don't even have that anymore.
It doesn't matter what his injuries were. They weren't caused by a car. He wasn't ran over by a car.
Yeah, I really don't think that anymore. And after the first trial, I actually think that was probably more likely than than the other things. I still thought there were other plausible alternatives, which means not guilty.
Yeah.
But now I don't even think that's the likely thing. So,
I don't know. Yeah. Well, we'll find. Well, I guess we'll find out. But Rachel, I know you got a hard out coming up, as do I. So we're gonna wrap this up. It was so much fun to talk with you and wrap with you again.
Always.
We will do it again sometime in the near future about some kind of a case. I don't know. We'll figure something out.
There's going to be more here, don't you think?
Oh, for sure.
There's going to be an amended complaint or an
Yeah.
appeal. I mean, it'll be an amended. Haven't they already said they're going to amend?
Yeah. No, they're definitely going to amend. The question is, Friedman kind of hinted at maybe he's thinking about how to handle an appeal.
Okay.
He said there's definitely appealable issues. Whether or not he does it now or later is the question.
And Liman has to unless they get all the claims knocked out, and I'm still fairly certain he'd still have to certify it. Liman has to certify it for appeal in federal court.
Yeah.
They don't have an appeal as a matter of right, even if all their claims are knocked out. I don't think.
Isn't it, if it's like a pure determination of law, just an interpretation of law, they could, what is it, Rule 54 or something like that?
Yeah, but he's got to certify under Rule 54, I'm pretty sure.
Yeah.
If it's not the final disposition of all claims in the suit, if it's only a partial disposition, I'm pretty sure he has to certify under Rule 54. This would meet the criteria that he should certify. But shit, I mean, their claims met the criteria of well-pled claims, and he dismissed those. So, I'm not.
I guess we'll see.
Yeah.
Yeah. Just for I'm sure that this question is going to come up for the people. How long do you think that if they do an appeal, now that it would stay the case for?
A minimum of 9 months.
Yeah. That sucks. Because you might get all the way to this point. Now we're just going to pause for 9 months.
I mean, give or take, right? But this is not going to be like, oh yeah, they'll shoot it back down to us in 3 months.
Oh,
right?
I know. Oh, you can give us 6 weeks, 6 to 8 weeks.
Yeah, no. I mean, I guess they could get it done in 6 months, but I doubt it. I would say 9 months, 12 months. I mean, long delay if they go.
I mean, if they expedite it, maybe 6.
Maybe 6.
I agree.
Yeah.
All right, Rachel, we're going to let you go. We'll be talking about this case again, I'm sure, in the near future, or maybe other cases. Maybe Karen Reed, which is about to conclude shortly. We'll have to come back on and rap about that case.
Yeah. And one day we'll cover the Harvey Weinstein mistrial that just happened today.
Oh.
Did you see that?
I did not even see that. So did that go to mistrial?
The jury foreperson refused to go back in and deliberate as a result of conduct going on in the jury room. So the judge was forced to declare a mistrial.
Really?
Yeah, it was sparks today. I haven't even gotten a chance to sit down and read everything, but I saw enough of it that they were having lots of problems with deliberations over the past 48 hours. Yeah. And today the jury foreperson came in and said, I won't go back into that room. I won't do it. It's been very ugly in deliberations. And so they had to declare a mistrial.
All right. I'm going to have to go home and read all about
that. I'm sorry.
Tonight.
I just gave you more homework.
Totally. I got this, the Diddy case, Karen Reed, and now the Weinstein thing.
I know.
So, but anyway, Rachel, you're the best. Thank you so much for coming on.
Anytime.
We will be in touch. And once again, Lauren Knighty sends her regards, and she left you gifts.
Hi, Lauren. You're the best.
All right. We love you guys all. Take care.
Yes, everyone. Bye.
Bye-bye.